Good morning, everyone. We're going to call to order this Thursday, February the 21st, 2013, meeting of the Tennessee Alarm Systems Contractors Board. Ms. Bess, will you please call the roll?
Yes, thank you. Keith Harvey?
Here.
Vivian Hickson?
Here.
Karen Jones?
Here.
Mackenzie Roberts?
Here.
Stephen Tucker?
Here.
Madam Chair, you do have a quorum.
Thank you. Has the board members had the opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Madam Chairman, I make a motion we adopt the agenda as presented.
I second.
Okay, we have a motion and a second to adopt the agenda for today's meeting. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Next, has the board had an opportunity to review the minutes from the November 15th, 2012 board meeting?
Make a motion to accept the minutes as presented.
Second.
We have a motion and a second to accept the minutes as presented. All in favor, voice by saying aye.
Aye.
Aye. Any opposed? Motion carries. Next on the agenda is the minutes from the hearing held also on November the 15th, 2012.
Madam Chairman, I make a motion that we adopt the minutes from the hearing that was held on November the 15th, 2012.
Okay, we have a motion. Do we have a second? Motion and a second to approve these minutes. All in favor, voice by saying aye.
Aye.
Any opposed? And last, we have the minutes from the November the 16th, 2012 hearing.
Madam Chairman, I make a motion that we adopt the hearing minutes from the minutes from the hearing on November the 16th, 2012.
Second. Motion and a second to approve the minutes from the November the 16th, 2012 hearing. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Next on the agenda, we have the election of officers.
May I ask the board please to pull the mics down a little bit closer to you?
Okay.
There we go. First of all, before we go to the election of new officers, I'd like to introduce you to your new staff attorney, Josh Kilgore's to my right. He will be our staff attorney for all our programs, including the alarm board. And we want to thank Andrew Simpson, who was our attorney, to my left, who's still going to be with us, but he's going to be with us as a litigator. We'll pick up all these old cases and try to get them resolved as quickly as possible. We expect big things from Josh here. This is his second meeting. He did attend the Private Investigation Commission.
Look forward to it.
Welcome you. Or Miss Andrew, although we know he's still going to be with us at times.
I'll be around.
Good.
Okay, we're going to call for election of officers. We're calling for a nomination for the board chair.
I would like to nominate Vivian Hickson as our board chair.
I second.
Seconded by Mr. Tucker. I have a motion to elect Vivian Hickson as board chair. We got a second already? Have a motion and a second for the election of, can I have a motion and vote for election by acclamation?
I make a motion that we close the nominations for the chairman position and that we elect Vivian Hickson by acclamation.
Right. Well,
We need
I second that. Karen's going to second that. All right. All in favor?
Aye.
Aye.
All opposed? Well, congratulations, Ms. Hickson. You're now the continuing chair for the Alarm Systems Contractors Board. Now, the next position we have, we're calling for nominations for the vice chair. Do I have any nominations?
I'd like to nominate Mackenzie Roberts.
Roberts has been nominated by Steve Tucker.
I'd like to second that nomination.
Karen Jones would make a second. Okay, I'm going to make a motion, and we have a second vote for election by acclamation.
Make a motion to
Make a
close.
motion to vote by
Mhm.
acclamation.
I
Yes.
second.
That's going to be Karen made that motion, and it was seconded by Vivian, correct? All right. And vote all in favor?
Aye.
All opposed? Well, congratulations, Mr. Roberts. You're our vice, continue with our vice chair. We'll get this down to a science if I've ever been here to stay long enough. Now we're going to vote for secretary. I'm going to call for nomination for a secretary. Do we have a nominee?
I nominate Karen.
Do we have a nomination?
I second.
Okay. That was Mr. Tucker?
Yes.
All right. I have a motion, a second for election by acclamation. Do we have a vote?
I make a motion that we close the nominations for the position of secretary and that we elect by acclamation.
I second it.
That was seconded by Vivian. All right, all in favor?
Aye.
All opposed? All right, congratulations. Mr. Roberts, you're vice chairman of the Alarm System Contractors Board again. Thank you. You made that so easy. I'm just going to have to start letting Ken do that from now
We
on.
get the hang of it after a while.
Well, we just do it once a year.
Oh, gosh. All right, now we're going to adopt Robert's Rules of Order like we always do, but we do have one change that it is where the chair can vote. I neither.
I make a motion that we adopt as our rules of order, Robert's Rules of Order, with the exception that the chairperson is allowed to vote.
I second.
All in favor?
Aye.
All opposed? Motion is carried. Thank you. Madam Chair, back to you.
Thank you. Next on the agenda is the legal report. Mr. Simpson, you ready for that?
Yes, thank you. Members of the board, before I begin the legal report, and I will also be reviewing the proposed rulemaking, and we'll discuss that after the legal. Joseph, a matter.
Good morning.
Jesse Joseph, Assistant General Counsel. I have a matter for you that is relatively brief on my supplemental legal report as to formal proceedings. This is a matter involving case number 2012-011401. In this particular case, this matter was previously presented to the board in July of last year, and a consent order was authorized against this respondent. The respondent is a certified alarm systems contractor located in California. At that time, it was believed that the respondent had employed an unregistered individual from January of 2008 through February of 2012. At the same time, the records of the Alarm Systems Contractors Board with Ms. Vest reflected that that employee was previously registered with another certified alarm contractor in Wichita, Kansas, starting in July of 2008 and ending on July 30th of 2009, according to the notice of termination that was filed with Ms. Vest's office. The respondent is a wholly owned subsidiary of the Kansas Corporation, or the Kansas contractor, and erroneously believed that this fact meant that it did not need to separately register the employee in question, which, of course, after we engaged in the investigation and after we consulted with the respondent, they understood that that was erroneous. They were two separately licensed contractors. But in any event, after this file was forwarded to me for the initiation of a formal proceeding last fall, we continued to investigate this matter along with the respondent's corporate general counsel, and upon continuing investigation with the counsel for the respondent's corporation, it was determined that the employee in question did not work the 49 months that we thought originally that the employee had worked unregistered, but that instead the employee had worked without benefit of registration for only 36 months, from February 11th, 2009 through her actual date of termination being February 22, 2012. In July of 2012, the recommendation for the consent order for this violation of Tennessee Code Annotated 6239.312C was for 49 months at $50 per month for a first offender, for a total of $2,450. Upon reinvestigation and our determination that the employee had only worked a total of 36 months, instead of the 49 as originally believed, the recommended civil penalty as a first offense should only have been an $1,800 civil penalty assessment, 36 months at $50 per month. Based on the reinvestigation, I and the respondent, we entered into a revised consent order assessing the $1,800 civil penalty and the $200 in investigatory and hearing costs, which the state incurred by the filing of the notice of hearing and charges in October of last year. The respondent has paid the entirety of the $2,000 civil penalty and costs, and that money even came in before the January meeting had to be canceled a day or two beforehand. So we had to represent this matter to the board because it was a different amount of the civil penalty assessment than what was originally approved. And we would recommend that the revised consent order that we recently negotiated and that the respondent paid, that after the filing of the notice of charges, be approved by the board. Thank you.
Make a motion to concur with council.
Second.
We have a motion and a second to concur with council's recommendation on a revised consent order in this matter. All in favor, voice by saying aye.
Aye.
Any opposed? Thank you.
Board, I will begin the legal report. I have 16 new cases along with one represent case that I will get to at the very end. The first case is 2012-026811. Respondent QA failed to submit 5 employee termination notices to the board within 30 days of each board received the 3 of the employees were terminated in January 2012, 1 in March 2012, and 1 in June 2012. In response to the complaint, Respondent QA stated this oversight was due to a clerical error, and the company has since instituted a new process wherein all employee registrants and applicants are reviewed every 30 days to be in compliance with the board. Therefore, my recommendation is to authorize a formal and send a consent order with a civil penalty of $250 for first offense for the failure to submit the termination notices with the rules stated therein.
Madam Chairman, I make a motion that we concur with the recommendation of council with a that would authorize a formal hearing and send a consent order with civil penalty of $250.
Second.
We have a motion and a second to concur with council's recommendation for a hearing, consent order, and a civil penalty of $250. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next case is 2012-026991. Complaint alleges that respondent company failed to properly display its certification number on its company vehicle. Complainant submitted a photograph depicting one side of respondent company's work van, displaying only the respondent's name and phone number. Respondent provided a response which included a picture of the rear side of the same vehicle in question, clearly displaying the requisite certification number. Furthermore, respondent stated that complainant failed to submit a picture of any other view of the van, which, if submitted, would have properly depicted the certification number on the rear of the vehicle. Therefore, my recommendation is to close this matter.
Make a motion to concur with council.
Second.
Okay, we have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next complaint is 2012-026992. 071. Complaint alleges that respondent, an out-of-state company, failed to display its certification number on its advertising materials, which were sent to Tennessee customers. Additionally, the alleged advertisements contained a company name different from that of respondent's name as certified by the board. In response to the complaint, respondent confirmed the materials were accidentally mailed out to Tennessee by a third-party service, which included respondent's newly formed name. Respondent stated that they had filed forms to add the DBA as an assumed name with the Tennessee Secretary of State's office, but that they have not received confirmation of its acceptance. In an effort to ensure compliance with the board, respondent further stated that no follow-up calls or monitoring services will be offered to Tennessee residents until they are properly licensed under the new DBA. Therefore, my recommendation is a letter of warning regarding the certification of numbers required to be listed on the advertising materials.
Motion we concur with council.
I second.
Okay, we have a motion and a second to concur with council's recommendation for a letter of warning. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Complaint is 2012-017-921. Complaint alleges that respondent QA failed to timely submit notices of termination of 3 employees within 30 days notification period allowed by law. 2 of the employees were terminated in April 2012. 1 was terminated in March 2012. All 3 notices were submitted to the board approximately June 21st, 2012. No response was received to the complaint by the respondent. My recommendation, therefore, is to authorize a formal and send a consent order with a civil penalty of $250 for the first offense, $150 for the failure to timely submit the termination notices, and $100 for the failure to respond to a complaint by the board.
Chairman, I make a motion that we concur with the recommendation of council here.
I second.
Okay, we have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
The next complaint, 2012-017-341. Complainant, a licensed alarm contractor, alleges that respondent employees held themselves out as either employees of complainant company or as affiliate of complainant's company with customers currently under contract with complainant's company. Complainant, who failed to witness such alleged violation, submitted this complaint based upon information received from his customers. Complainant provided no further evidence of respondent's alleged improper dealings other than the above referenced statement and the names of such customers. In response to the complaint, respondent stated its records indicate there was no such respondent employee or other such interaction or attempted contact with customers located in or around complainant's area of Tennessee. Legal's attempt to contact customers in question who allegedly witnessed such improper dealings by respondent employees was unsuccessful. There is no other sufficient evidence contained in the complaint to prove the allegations made by the complainant company. Therefore, my recommendation is to close this matter.
I concur with council.
I second.
We have a motion and a second to concur with council's recommendation to close this case. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next complaint is 2012-026-771. Complaint alleges that respondent failed to register 5 employees within 30 days of their employment. The board in June 2012 received 5 employee applications for registration, all of which listed date of hire and registered position as January 2012, December 2011, April and May of June 2012, and June of 1995. In response to the complaint, respondent company states they are a multifaceted company with several divisions, including fire extinguisher sales, service, industrial dry chemical sales and services, sprinkler installation, restaurant sales and service, and emergency light sales and services, along with the requisite alarm system contracting division certified by the board. Respondent states the above referenced employees all transitioned to the registered positions within the 30 days of submitting the registration application and were not involved in any such alarm systems contracting prior to being transferred to such positions. The complaint also alleges that respondent company failed to notify the board of its DQA's termination within 10 days of the DQA being terminated by the respondent, and subsequently failed to find a replacement DQA within the 30 days of such DQA being terminated. The board received a termination notice from the respondent DQA in January 27, 2012, indicating that he had been terminated by the respondent company effective December 28, 2011. Subsequently, the respondent failed to provide the board notice that it employed a DQA, a replacement DQA. In response to the complaint, respondent stated that when its former DQA was terminated, its other licensed branch office DQA assumed the responsibilities for operating respondent's branch until a new DQA was hired. Respondent company therefore operated without a DQA for approximately 9 months. Respondent company's license expired September 30th, 2012, wherein they failed to timely submit a proper renewal application within the requisite 3 months lapse period, but has since reapplied and obtained a new license as of January 2013. Therefore, my recommendation is to authorize a formal and send a consent order for a civil penalty of $1,500 for the following offenses. The $250 for the failure to notify the board of the DQA ceasing duties within 10 days, as stated in the rule herein. $500 for failure to replace the DQA within 30 days or request an extension for the rules stated herein. And is $750 for operating without a licensed DQA first offense for the statute stated herein, totaling $1,500.
Make a motion, we concur with council's recommendation.
I'll second.
Okay, we have a motion and a second to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next complaint, 2012-026741. Complaint alleges respondent failed to register an employee within 30 days of employment. The board received a transfer notice from respondent company in November 2012, indicating they employed the individual since August 2012. And in response to the complaint, respondent DQA stated they hired the individual on a part-time basis in August 2012 and worked him in such part-time capacity until converting him to full-time in November 2012. Therefore, my recommendation is to authorize a formal and send a consent order with a civil penalty for $100 for the 2 months of unregistered.
I make a motion to concur with council.
Second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Next complaint is 2012-026511. Complainant alleges that respondent company representatives promised to cancel her existing alarm monitoring contract with another company upon signing a new contract for monitoring services with the respondent company. Complainant alleges that her existing contract was never canceled and that respondent company failed to properly terminate such agreement and rectify the issue. In response to the complaint, respondent stated that its company did agree to a buyout of the complainant's existing contract and advised her on 4 separate occasions of her responsibility to forward the necessary documentation required to complete such buyout. Nevertheless, respondent agreed to refund the complainant's money and to terminate the contract with respondent company. Therefore, my recommendation is to close this matter.
I make a recommendation to concur with council.
I'll second.
Okay, we have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
This complaint is 2012-019961. Complaint alleges respondent was offering alarm installation and maintenance of alarm systems via its website. After an investigation, it was determined that an independent hosting service hired by respondent had accidentally allowed a draft of its website that was not supposed to be publicly viewable to be viewed by any visitors to the site. Respondent stated to investigations that upon realizing the error in advertising for alarms, respondent immediately removed the alarm security content from its website. Respondent states that this was just an idea that they had about business expansion in the future, but have decided not to pursue it at this time. Respondent states that at no time did they install or maintain alarm systems. Therefore, my recommendation is a letter of warning regarding the licensure requirements for the Alarm System Contractors Board.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
I second.
Okay, we have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next complaint is 2012-026801. Complaint alleges that respondent QA failed to timely submit termination notices for 12 employees. The board received the notices in November 2012, which stated respectively that the terminations occurred from January 2009 to May 2010. Respondent states that this oversight has been rectified and will ensure that such mistake does not occur in the future. My recommendation, therefore, is to authorize a formal and send a consent order with a civil penalty of $600 for the first offense for the 12 employees for the failure to submit the timely termination notices for the 12 employees.
Okay.
Make a motion, we concur with council.
Second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next complaint is 2012-025-911. Complaint alleges that respondent, a telecommunications company, engages in alarm system contracting without proper licensure from a board. Respondent company's website advertises for the sale and installation of residential, commercial, industrial intrusion systems, video surveillance systems, access control systems, home automation, and audio-video systems. Additionally, respondent currently maintains an electrical contractor's license with the Contractors Board. In response to the complaint, respondent representative stated it was under the impression that it could engage in such alarm system contracting under their electrical contracting license with the Contractors Board. After being made aware, however, of such alarm contractor licensure requirements, respondent stated it would cease and desist immediately from engaging in such activities until such license is obtained and that it can lawfully perform such services in the state of Tennessee. As of the date of this report, respondent has not submitted an application for an alarm contractor license. My recommendation, therefore, is to authorize a formal and send a consent order with a civil penalty for $5,000 for engaging in unlicensed alarm activity.
Andrew, is this an out-of-state company or an in-state company?
In-state company.
In-state company.
They have a Tennessee electrical license, don't they?
They do, and that does not coincide with the board's currently accepted exception for the Contractors Board.
I agree. I want to make a motion to concur with council.
Second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? One thing, you need to add something in there about your code numbers and so forth.
Do they need to make whatever that is part of their motion?
I think it's okay. All right, the next case is 2012-023-911. The anonymous complaint alleges that 3 unregistered employees from respondent's company distributed advertisements to potential customers. Complainant failed to provide copies of such advertisements or any other evidence indicating the alleged unregistered employees' involvement in the selling of alarm systems. In response to the complaint, respondent states that the employees work in a non-security related positions with 2 of respondent's other companies and do not engage in selling, installing, or monitoring alarm systems other than distributing such advertisement flyers. Respondent owner, who is also the QA, also stated that he is fully aware of the registration requirements for his employees and will submit an application for registration for such employees if their duties include the actual sale of alarm system to potential customers. No previous discipline was found against this respondent. Therefore, my recommendation is a letter of warning regarding the registration requirements for respondent employees.
Madam Chairman, I make a motion that we concur with the recommendation of council for a letter of warning in this particular matter.
Second.
Okay, we have a motion and a second to concur with council's recommendation for a letter of warning. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Next complaint is 2012-026-831. Complaint states that respondent company failed to register 4 employees within 30 days. On September 4, 2012, the board received the above referenced employee registration applications, all of which stated the date of hire and registered position as June and July of 2012. In response to the complaint, respondent vice president indicated that such employee applications were properly filled out and signed by the respondent DQA within the 30 days of the individual's employment, but due to a clerical oversight, The applications were submitted late. Therefore, my recommendation is to authorize a formal and send a consent order with a civil penalty of $1,400 totaling the 14 months of unregistered employment which is a second offense for this respondent company, totaling $1,400 per TCA 6232-307D.
Make a motion to concur with council.
I'll second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
The next case is 2013-000321. Complaint alleges respondent failed to properly display their alarm contractor's license number on their website and company Facebook page. Respondent company stated that this was an oversight on their part and that has been remedied. This statement was confirmed by Assistant General Counsel Josh Kilgore in January, and upon assessing both of the company web addresses provided by the complainant. Therefore, my recommendation is to issue a letter of warning regarding the advertisement requirements stated herein.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
I second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Next case, 2012-020741 and 2012-020761. This involves two separate licensed alarm companies, and I will hopefully try to clarify the issue. It's pretty lengthy here. Complainant is the CEO of a licensed alarm contractor. Alleged in both complaints that several of her customers were approached at their residence by an individual not registered by the board who attempted to sell the customers' alarm systems. Complainant stated the individual held herself out as a representative of respondent company number 1 and would harass the customers utilizing aggressive sales tactics in an attempt to convince them to change alarm accounts to respondent company number 1. Complainant also alleged the same individual engaged in similar unethical and unprofessional conduct during attempts to sell alarm systems on behalf of respondent company number 2. Therefore, both complaints allege respondent companies employed an unregistered individual to engage in the sale of alarm system on behalf of their respective companies. Investigations obtained sworn statements from the following customers in regards to the allegations concerning this unregistered individual. The first customer stated the individual had approached the residence and engaged in aggressive sales tactics, attempting to sell her a burglar system to be installed by respondent company number 1. She further stated that subsequent to the installation of such system, the system was not correctly installed, at which point the unregistered individual stated that she could cancel the contract and sign up for a new contract with respondent company number 2. Customer stated the individual held herself out as an employee for both companies and never produced a valid registration card. The second customer also alleged similar conduct on behalf of the unregistered individual, wherein the individual represented herself first as an employee of respondent company number 1 and later as an employee of respondent company number 2. Customer stated that she misled the customer into signing 2 contracts and was being billed for the 2 alarm systems. Customer number 3 alleged similar deceptive behavior by the individual who represented herself out as an employee of both respondent company number 1 and 2. In response to the complaint, the owner of respondent company number 2 stated the unregistered individual was married to a registered employee of respondent's company and that she would refer customers to respondent's company on behalf of her husband. Respondent owner stated that she was not formally employed by the company until August 2012, wherein respondent company submitted her registration application in September 2012, which is still in process. Investigations obtained a sworn affidavit from respondent company number 1 owner and its DQA, both of which stated they hired this individual in or around the same time as respondent company number 2 for purposes of referring potential customers to their company. Additionally, they stated that she was eventually terminated for engaging in unethical conduct, further admitting they failed to register her with the board. Investigations, after many attempts, interviewed and obtained a sworn statement from the alleged unregistered individual, stating that in July 2011 she was contacted by the respondent company number 1 owner, who gave her respondent company number 1 contracts for purposes of referring customers to his company. She further stated that in early 2012, she and respondent company number 1 owner had a falling out, wherein she started referring customers to her husband's employer, respondent company number 2. In conclusion, both companies admit they employed this individual for purposes of referring them customers, and that based upon the statements from such customers, the individual did not engage in referrals. Rather, she was engaged in the actual sale of alarm systems on behalf of both companies. The individual's conduct during the sale of the alarm systems was intentionally deceiving, which resulted in the customers being misrepresented as to the nature of their alarm contractor. My recommendation, therefore, for the respondent company number 1 is to authorize a formal and send a consent order with a civil penalty of $1,000 for employing this unregistered individual, and for respondent company number 2 to authorize a formal and send a consent order with a civil penalty of $1,000 for employing this individual without proper registration.
Andrew, this is pretty reprehensible conduct on the part of this particular individual, and inducing people to sign contracts as apparently, and do I understand that the person doing this was a female?
Yes.
Okay. Not that makes any particular difference, but it seems like where she induced customers to enter into contractual relationships with you, that borders on fraud, doesn't it? Doesn't that border on criminal activity? I'm just asking. That seems to be very serious to me.
Well, she was married to an employee of one of the respondent companies, and apparently is very good at selling alarm systems. So these company owners wanted her to refer customers. She went over and beyond such conduct and was actually selling the contracts to the customers. It was deceiving. The customers were very confused as to who are they signing up with? Is it company 1 or 2? From the owner's standpoint, I think they kind of didn't really have a leash, quote unquote, on this individual, and just pretty much had an understanding with her to refer them customers. I think based on respondent company number 1's statement that once they found out that all these customers were being misled and as to her unethical behavior, they did terminate her. But both of them do admit that company number 2 adamantly believes that the referrals do not dictate a proper registration with the board, and that it is merely referrals and not the actual sales. Our evidence obtained by investigations reflects otherwise. The length of time Mr. Roberts, on the length of employment with these companies is not very clear. That's why my recommendation for $1,000 was kind of a base number.
I really didn't have a problem with your recommendations with regards to the companies. I quite honestly felt like that was relatively appropriate. My concern was on the part of the individual that's out inducing people to enter into contracts, and it would seem to me that her action was the one that was especially reprehensible. I felt like your recommendations with regards to the companies themselves was probably quite appropriate. But on the other hand, the person that was actually doing all this and that was out contacting the clients or customers and getting them to sign contracts and all, she goes unscathed as a result of her actions. And I'm wondering if further action should be taken in that regard, rather than, like I say, I agree with your company's recommendation.
As to the employee, she is, her application was submitted to the board. It's in process. The board can make a decision as to her application, although that her application her materials are not here today, but based upon her conduct that the investigators gathered, through the evidence that they gathered, I think that her fraudulent, dishonest, and improper dealings with customers would constitute a denial of her application, which the board may, at their discretion, approve the denial, which would prevent her from being registered with the board. In terms of going forward with any further disciplinary actions, such as civil penalties, which would be the only recourse here, seeing that she doesn't have a registration right now, would be she is not a respondent in this matter currently. The board would have to most likely open a complaint against her as a respondent to seek disciplinary action if they see fit in the for civil penalties, which would be most likely the only conduct.
Will her
or
application automatically be brought before the board to be reviewed? Will we have an opportunity to speak to her about this and explain to her why we're going to deny her, or will it just go on
I think
through?
that would probably be the most likely. I'm not sure where we're at in terms of her application, but in terms of at some point in the future, I think it'd probably be necessary for her to explain her actions. But if we open a complaint, that would probably, we probably couldn't, seeing that if there's an open complaint, I would recommend the board not be involved in such discussions, seeing that there would be an open complaint against her, which would therefore, disqualify the board from having attending a formal hearing in the future. So, I think the board can, at this point, decide or determine to deny such application based upon the evidence of her misconduct, if they see fit. I do not have like a registration number with me right now or an application number.
Oh, when that one comes before us.
Yeah.
Tell you what, let's do. Why don't we take care of this in pieces? That sounds a little bit strange, but seems to me to be a reasonable way to deal with this. Let me make a motion that we concur with the recommendation of council, which would involve authorize a formal hearing and offer a consent order with a civil penalty of $1,000 to each of these two companies. That's the recommendation of our council, and I think that would be very appropriate. And then let's discuss the matter of the particular person involved separately. So I have that as a motion then.
I'll second that.
Okay, we have a motion and a second to concur with council's recommendation on the civil, authorize the formal and consent order with the civil penalty on these companies. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Now dealing with this particular individual, like I say, I'm concerned that this person has been apparently engaging in this behavior pattern. I think the investigation bears that out. I think that application for employment should certainly be given some sort of special scrutiny. And like I say, I'm concerned that her actions here really kind of, I'm not enough of an attorney to determine what's criminal and what isn't, but it would seem like that some of her actions border on the criminal. I would think that our council should take a good hard look at this case in her particular instance, and perhaps come back with some recommendations as to appropriate response to what's taking place here.
I also think that the word referral means you refer it to a company, but she's having a contract signed means you're an employee, right?
She based on the evidence here, she's engaging in sales rather than just referrals. And although the companies may call them referrals, well, it really goes beyond that. Like I say, I would like to see our council come back with some additional recommendations, or perhaps some further action should be taken with regards to the individual that has been the center of all this.
Hey, can I ask? I have her application in my office. There's no complaint against her. There's no criminal history. There's nothing to flag me to bring her back to you if I don't have a complaint. What am I going to say? She's going to come back because of her?
Didn't have a
What-
registration
She-
number
she-
yet, does she?
Right, but I don't bring all registrations to you.
That's what I'm
If it's
hearing.
clean,
It was
I
go
have
right
to have a
through, we'll
reason
not
to
know.
bring her to the board.
Is she currently registered?
No.
No.
Well, she's,
And so she
Would this
applies
not
for
be,
registration, it could
would
go
this
straight
not be
through.
grounds for you to bring her before the board?
I think it would be very appropriate. I really do.
That's our concern, is how we can
I
filter
got
that
that,
out.
but how do I do that without a complaint? Are you filing a complaint against her so I can hold the application for you to review it?
I
How
don't,
do
I don't
do
think you
that?
have to file a complaint. I
We,
think
we've
it-
got a complaint here,
The
and
complaint is
she's
not
involved in
against-
it.
The complaint's not against her.
it's not against her, it's against companies.
This complaint, where I read,
But
it's
I
not
mean,
against her at all.
Based on this, we know that there has been questionable, deceitful activity on her part as an unregistered employee. So I think the board's question is, why would we grant her employee registration having this knowledge? Is that correct?
I don't
And how
dispute
can we
that, I
stop
just
it?
gotta,
What-
I just wanna know how to bring it.
I don't want to prejudge her application, but
Right.
because we haven't had an opportunity to hear her side of this. But I would think just the investigation that's been done on, that our council has done at this point would be sufficient basis to open a complaint against this particular individual, even though they're unregistered.
That's
And
the complaint is unlicensed activity, is it
Right.
not? Unregistered activity? And well, what she
No.
did at that particular time?
I would
Then
think
this
that
is
would
an open
be
complaint.
a plenty basis to open a complaint and let you hold her registration and bring her back to the board. Because like I say, I don't want to prejudge this individual. We've only heard one side of it. I'd like to hear what her side of this thing is before we consider an application.
That's all I'm going to, going to defer to a
That makes
attorney.
sense, Andrew?
You
I
just
mean,
gotta
is
have
that
a
a
reason
reasonable
to tell her
thing?
she's coming.
Yeah, it does. I think maybe the proper action would be to, if the board wants to pursue disciplinary action against this individual in the form of civil penalties and/or referral to possibly a district attorney's office for potential criminal investigations into her behavior, that is, if that's something the board would like to do, we could open a complaint that would, at the same time, if she comes before the board, like I said, on behalf of her application, and you're discussing the nature of the complaint with this individual, it would compromise the board's ability to be a part of a potential formal hearing wherein it would be in front of an ALJ only. I wanted the board to know that from that standpoint. You can still do it, but you won't be able to.
Yep, that makes sense.
Same
I
thing.
understand what you're saying.
But are you also saying she can say, well, I wasn't registered, I didn't know the rules? Are you,
I'm not sure what her response is going to be, but I think we could definitely open up a complaint and proceed accordingly, and then she would be scheduled if she would like to have her opportunity to appear. If not, we could present formally an application review to the board containing the evidence we have, and you guys can make a decision as kind of the normal procedure with application reviews.
I think that's an excellent.
And I think as the council pursues this matter a bit, I think probably it'll make a little more sense as to an appropriate course of action at that point.
But we agreed to set up a complaint?
Yeah.
Can a wife represent a husband in a contract? Is that, and I'm just asking.
I'm not sure exactly if she was representing him. It was more the company. She was just married to the individual. That's how they had the connection.
I think if we got a complaint open and
That's
that
what
would
she was doing.
that would give us a basis for council to consider this matter further and then bring it back to the board based on what council would consider to be appropriate action. Whether we want to carry this to some sort of formal hearing or turn it over to a district attorney for as some sort of fraud basis, and it would seem that this skates pretty darn close to that. But let's let the council take a look at this and decide an appropriate course of action. By opening a complaint, then that gives our staff an opportunity to put a hold on this registration until the matter can be better resolved.
Right, heard first, you
I don't think we really need
You
a
don't,
motion. I think,
you don't think we need a motion, correct?
Yeah.
I think he can just do it.
Fine. You made the motion on on this complaint?
Yeah,
It was
we've dealt with the companies, and I think
Right.
we've taken an appropriate action there.
Okay. Next complaint, 2012-02-6851. The board received 2 termination notices in November 2012 signed by the respondent QA, both of which stated the date of termination for its employees as September and July of 2012. A representative for the respondent company signed for the complaint on December 27, 2012, and the board has yet to receive a response to the allegations. My recommendation, therefore, is to authorize a formal and send a consent order with a civil penalty of $200 for the failure to submit the timely termination notices and the failure to properly respond to the complaint for the rule stated herein.
Are you done, Beth? I make a motion we concur with council.
I second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
The last complaint is complaint numbers 2012-019741, 2, and 3. 3 respondents in this matter. It involves 1 company and 2 qualifying agents. Complainant is the owner of a licensed alarm contractor, alleges that 2 former employees, both of which hold qualifying agent licenses, conspired together to take her customers and transfer their monitoring accounts to an unlicensed company, which was formerly operated by one of the respondent QAs. Complainant alleges that one of the respondent QAs, who formerly owned that now expired alarm company, worked with the other respondent employee, who is the DQA for the company, to transfer the complainant's customer monitoring accounts to this now unlicensed company. Complainant also alleges the respondent monitoring company joint ventured with this unlicensed company by and through the actions of respondent employees to provide monitoring services for the unlicensed company. In response to the complaint, the respondent monitoring company stated that both respondent employees approached the monitoring company in or around 2010 for purposes of transferring the complainant's customer accounts to the expired alarm company's account. Respondent monitoring company was under the impression at the time the respondent employees were in the process of obtaining a new alarm contractor license. Additionally, respondent monitoring company provided a letter dated subsequent to this complaint being initiated from one of the respondent employees stating that all such customer accounts be transferred back to the complainant's company. Investigations attempted to contact the complainant, but was unable to make contact for purposes of obtaining further documentary evidence of the respondent employee's unlicensed conduct. Additionally, investigation attempted to make contact with both of these respondent employees, both of which failed to comply with such investigatory requests in regards to these allegations. Therefore, based upon the information received by the respondent monitoring company, it appears that at some point in 2010 and 2011, the respondent employees contacted the monitoring company and successfully transferred complainant customer accounts to an unlicensed company. There is no evidence to suggest the amount of accounts transferred or the degree in which the respondent employees engaged in such unlicensed behavior based upon their unwillingness to comply with our investigations. Therefore, my recommendation for the respondent monitoring company is a letter of warning regarding the joint venture with unlicensed companies. As for respondent QA number 1, this individual's QA license has recently expired. My recommendation is to close and flag this individual's account, wherein if this individual attempts to make a new application, the complaint against him would be reopened and would prevent him from receiving an application until resolving such complaint and responding to the complaint. As to respondent QA number 2, who currently holds an active QA license, my authorization is to, or my recommendation is to authorize a formal and send a consent order with a civil penalty of $5,000 for operating an unlicensed company, along with engaging in false, deceptive behavior while under the employ of complainant's company.
Andrew, the respondent monitoring company, are they licensed?
Yes.
Okay.
What was the time frame from when these customers were transferred to them until they realized there was a problem? Was that brought to their attention by the state, or did they?
They responded in response to this complaint. The monitoring company. They were the only parties in this matter that were very cooperative with our investigators.
So they weren't aware of the unlicensed activity
No.
until the state, but they immediately took action.
Well, they provided a letter actually in response to the complaint. The only correspondence we have from one of these respondent employees was a letter that the respondent employee sent to the monitoring company saying, send all the customers back to the complainant's company. Probably because this respondent employee received the complaint and knew what was going on, and so the issue was more or less rectified by transferring the customers back. But in terms of the degree of any other unlicensed behavior, I just don't have it at this point. That's kind of where we're at on this case.
So it sounds like the monitoring company acted in good faith.
I think, yeah, definitely.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
I second.
Okay, we have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
Any opposed? We need to put your TCAs in there again.
I will.
Thank you.
I have a represent case here. It had been presented to the board originally at the July meeting, I think. It involves case number 2012-010941. The respondent DQA failed to submit a termination notice within 30 days. I had previously recommended a $150 civil penalty based upon his failure to respond to the complaint. However, it was determined subsequent to me presenting it to the board that the respondent had indeed responded timely to the complaint. Therefore, the recommendation should be amended to reflect the civil penalty for $50 rather than the $150 due to his timely response to the complaint.
Make a motion that we make a change in the
Second.
We have a motion and a second to concur with council's recommendation on this presented case. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Take a break before you do that.
Yeah, I guess we'll take a quick break. I wanted to formally present the notice of rulemaking hearing that we had discussed at a previous board meeting in November on some proposed rules. I've drafted a copy of the notice that I would be filing with the Secretary of State's office, and wanted to and have been granted the authorization from my deputy counsels and chief counsels to proceed with the proposal to the board. But I wanted to present this formally to the board, get a vote on proceeding with the rulemaking hearing, and discuss the requisite regulatory flexibility requirements and economic impact statements that coincide with filing these rules. But we can do that after the break.
Going to take a 20-minute recess. Call back to order this February the 21st, 2013 board meeting of the Tennessee Alarm Systems Contractors Board. Let's see. What do we have next?
Yes, it shouldn't take very long. We had discussed these proposed rules at a November meeting. I drafted the notice of rulemaking hearing, and it should be in front of you. We need to just go through it and vote on, give me the authorization to proceed with the filing of the rulemaking hearing, which would be most likely at the May meeting time. Basically, just to reiterate what we had went over and that included in this document, the first rule that will be amended involves the employee registration requirements, basically changing the expiration of the registration from the 24th month of the alarm contractor's date of expiration to basically the 24th month of the time in which they are issued the registration. Therefore, the expiration would not coincide with the alarm contractor anymore. That would be the significant change there. Everything else would remain the same. The alarm contractor is still responsible for submitting, paying, doing all that. It's just their expiration of these employees would be on an individual capacity rather than all of the employees being renewed on the contractor's renewal date.
Right, and I'm working with IT whenever we make the conversion over. Everybody who is already established and already it has been issued will get the same expiration date as the company. But there's no way that we can continue to do that as new employees are hired or transferred.
Is that going to add any substantial administrative burden? Yes.
I don't believe so. I believe it's going to make it easier for our department to handle this because we're already familiar with all our other programs that do the same thing. We know how to get the licenses in. We laminate, put the photos on. We have the staff that can do that. It's going to help us know who works for what company. It's going to help the companies know who their employees are because they're going to be getting licenses when it comes time to renew. And I'll go ahead and tell you now, all our programs are on online renewals now, except for the alarm board. We held all on that until we could get these rules changed, so they could physically go online. The problem that they were addressing was, in your case, if you had 3,000 employees, every one of them that you went online or they went online, it's going to be a fee like $2.50. But that has been taken care of too. There's no additional fees. That would
Being able to renew them online was, that would reduce your administration. I was just concerned it was a lot of extra paperwork and difficulty for staff. And
we don't think it will be. We looked at that. It's more difficult the way we're doing it now and trying to keep up with it. And we're trying to go paperless. It's going to make it so much easier. It's going to be so much better for the companies with these transfer notices. I have made a change in the office that you probably be made aware of in conjunction with this, getting ready for this. These alarm companies have difficulty knowing who their employees are. For some, I'm talking about perhaps a lot. So when they send their renewal in, they're sending, of course, the required list of your registered employees. So my staff has to sit there and start picking out one by one, looking on the computer, marking out, okay, then we'll stop it and going, hey, what happened to this one? Then we have to stop. We have to send the letters out. That's not going to happen. I stopped that. I put the responsibility back onto the company. We're going to accept what they send in to us, the amount of money, and then whenever this change is being made, if they don't know who works for them and they don't get the information in, we're going to be setting up complaints against the companies. They have got to take the responsibility for who their employees are, not putting it on the state.
Is the company going to be responsible and fined, or the QA for the company?
This would be a company thing. Company responsibility. They're responsible for submitting the registration and renewing the registration. So,
when you said this is way off base, and if we're going to talk about it later, just tell me to hush. You were talking about renewing online. You've got everybody else doing it, but the alarm contractors. Did the Prometric contract that ran out in December, did they re-up or we don't have
We're
nobody
going to
doing
talk
the
about
test?
that, but the answer is no, they have not.
All right.
Will the company still be getting notices to renew their,
The renewals will still be going to the companies. Everything goes to the company. Still will be going. The licenses will still be going to the company, just like they do now, except they're going to have an expiration date on them, and they're going to have to renew.
they've got a lot of employees with different registration dates, and they're going to be getting notices on each one of these employees?
Yes, sir. Was it about 60 days in advance for this program?
90 for this program.
For this program, okay, they're going to be like anybody else, get a 90-day notification. Get a
They can
renewal
renew
form, send it
online,
to the
which is,
company. That's
being able to renew it online should simplify the process
Yes,
there.
we certainly hope so.
They'll still have to send us 2 pictures,
Photos.
either electronically or by mail. But
We got this started, so the next step is getting that done electronically as well.
Sense?
So, if we have that capability now, they can send it to the email. We just print them off the color printer. So we got it started, what the other programs are doing.
That sounds like it'd be a step forward in reducing the staff burden. I was concerned that it might be adding to it, but you've explained it where it does not seem
It's
that
going
way
to
at
be a little
all.
bit of an adjustment to it, but we know how to do that.
I don't see it as any particular added burden onto the contractors either, especially if they can do all the renewals online, then that hopefully would simplify the process. Good, okay.
So that's kind of the first amendment to proposed amendment. The second amendment concerning QAs is really a housekeeping issue. It's in regards to the notification of a conviction to be sent to the board. There's a code section in there that was listed wrong, so I wanted to make sure it was changed to the correct code section. So that's really housekeeping. That's the first two right there. And then the third one here, the renewal, would be adding a rule stating that the contractor, upon renewal, shall submit a notarized statement to the board identifying the number of employees registered, as well as a list containing the name and registration number of the employees. That's already something that we have done with the renewals. It's just not been something we've put in the form of a rule. And then the following are new rules. These were rules, all of the new rules that are proposed right here concern standards of conduct with alarm contractors and their employees. Kind of sectioned it out in terms of, door-to-door solicitation, standards of conduct and ethics involving the sale and installation of systems, basically trying to set forth to the contractor and the employees the type of conduct the board more or less would require from its licensees and registrants when dealing with citizens of this state, adding more of a higher standard to the industry as well. And these standards of conduct coincide with the national standards of conduct that the alarm industry utilizes. The fourth one is a section regarding the contract when contracting with customers, basically setting forth standards in which the contractor shall engage with customers when presenting the contracts to them, in terms of allowing them or disclosing what rights and obligation the customer has, making sure everything is conspicuously disclosed and that the customer is aware of such cancellation charges and all of that. As you probably are aware, that's been an issue over the years for customers, and I think this would set forth a higher standard for these companies, and it may take more training. It may take on part of the contractor when they train their employees, but I think hopefully it will reduce the amount of complaints, not only with our board, but with consumer affairs and with, civil lawsuits, stuff like that, in terms of all these different customer complaints we've seen over the years. If there's anything in these rules that the board doesn't feel comfortable with, that's the reason we're here today, is to discuss whether or not to include it. I can obviously amend this when filing it. This is not the final version. So if there's anything that the board doesn't feel that should be included in a proposed rule, please feel free to identify it, and I can certainly take it off.
Well, isn't this the same set of rules that you presented before?
Yeah, it is, and I had presented more of a Word document. This is set forth in how I would file it, and how it would be disclosed. Yeah, formatted within a rule.
We need a vote on this, or is it?
Yeah, if the board reviews it and feels comfortable with proceeding, taking a roll call vote, or just a motion to approve council to proceed with a rulemaking hearing on these proposed rules as presented to you, yeah, I would appreciate that. I have one more thing I'd like to review with you, and it's required under the Tennessee Code Annotated. It's in regards to when filing these proposed rules, not only with our board, but with any board, the state would like for the board to discuss what kind of economic impact these rules may have on small businesses, the contractors. Do you foresee any burdensome issues that would go along with this that would affect customers or the citizens of the state or the contractors involved? So when thinking about that, if I would probably recommend a second vote stating that the economic impact was reviewed and there is no probable effect negatively on the small businesses in the state with the proposal of these rules, unless there is, obviously.
Basically, these rules are protecting the consumer, except for the registration rules. So
There are no fee increases. The fees
Right.
are not discussed at all in these rules.
I think the refund policy issue doesn't affect anybody. I don't think that's something that we as contractors talk about with customers a lot, but that's a good idea.
Yeah, I'll just go ahead and read through it, so we'll have it on the record. And the first question is the types and estimated number of small businesses directly affected. The second is the projected reporting, record keeping, or other administrative costs that might be incurred from the proposal of these rules. The probable effect on small businesses, less burdensome, intrusive, or costly alternative methods that might be introduced. The comparison with federal and state counterparts, and the effect of possible exemption of small businesses. In terms of federal and state counterparts, I think there are other states that have a standard of ethics, professional conduct kind of either statute or rule. So I think that would be something we would be joining in terms of other states that do this kind of rulemaking or statutes. In terms of businesses, I'm not sure what the administrative costs might be. You guys might have a better sense of how much impact that might have on a business.
Sounds like there are two issues we need to bring up and take action on. First of all is the, approval of the rules, proposed rule, authorizing Andrew to proceed with filing for a rulemaking hearing. I would make a motion that we approve these rules. We wouldn't actually approve them until after we have a rulemaking hearing, but I would make a motion that we authorize Andrew to proceed with a rulemaking hearing on the rules as he's presented them here.
I second.
Okay, we have a motion and a second to authorize Andrew to proceed with these proposed changes and new rules. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
The second issue is to consider, if I'm correct, the cost impact, and in particular on small businesses. There would be some, I would expect, but I would expect them to be relatively minor.
You'd have to register your employees anyway.
Yeah, I'm not, the registration, right now they do it one time, they'll have to do it a few more times a year. But if it can be done online, then that's going to simplify the process, and in my mind, that's going to largely offset the added requirement that they have to do that on a regular basis instead of once a year would be largely offset by the ability to do it online. I would feel that the cost impact there is kind of one washes out the other. The contractual language that is in here, and additional training for employees that needs to take place in order to fully comply with the solicitation and the code of conduct, and standards of conduct, and the standards of ethics. I think there will need to be some training that companies will need to do. I'm not sure how we'd go about quantifying that, but I guess we really need to attach some figure to this in order to meet the requirement. Am I right in that, Andrew?
The purpose of this is just to be able to disclose on the record that there could be a monetary impact on proposing these rules. That is not, we don't know what that number is, but the board is aware.
I noticed on these continuing education courses, there's one in here, ethics for the security industry. So it's something that could be incorporated even into that.
And I think our requirement now for, red level 1, level 2, that's already there, so it's not, that part's not going to change. There are classes, and they do talk about some of those issues in level 1.
Well, I think with these rules in place, that the company is going to have to educate their employees to let them know what's involved, what the obligations are, what standards of conduct are expected, and there may need to be some contract revisions to comply with some of these on the last of the rule changes here, the last page.
Are you talking about refunds?
No. Other than there may be some of these things that will need to be included, may need to change some of their standard contracts, but that really, I would not consider that a major expense to any of the companies. In terms of small companies, small businesses, I guess I would consider the total cost impact of any contract changes, training to their employees for a small business, and I don't know how we're going to define a small business, but I would say for a small business it'd be less than a couple $100. That would just be my guess. I consider our company a small business. We don't have hundreds of employees, and so I would guess that we would, if we have to do some contract language modification and spend an hour or so training our employees or just making them familiar with the new code of conduct, $250 would be a reasonable cost for that. It'd be a one-time cost. For larger companies, it'd probably be a little bit more than that because they'd have more employees involved, but still would not be a burdensome expense.
Well, I just thought of this. That might be offset. That cost could be offsetted by if the employees are trained to a higher standard. That might reduce the amount of having to refund customers money
Right.
due to bad contractual, not being able to disclose. I know a lot of companies refund to customers if something during the sale was not disclosed. So that might, a higher standard for the employees might reduce that, which in turn might be beneficial for the companies. I'm not sure.
I really suspect that the smaller companies are probably trying to do most of this anyway.
Right.
They tend to have a little more personal interaction with their customers. I really feel like it's the really large companies that hire thousands of employees and legions of sales force to come in during the summer, and I really feel like those are the folks that really need the training more. I don't see anything here that's particularly burdensome on the small business. Do we need to make a motion, or just the fact that we've considered?
As long as you've, on the record,
We just have to, he wants to state it.
maybe just to cover the basis, maybe make a motion that the economic impact of these proposed rules was discussed by the board, and that the effects are minimal, and that the proceeding is.
I second.
Second that motion.
Let's have the board make the motion.
I know.
It's always better to be more compliant.
Well, I'll make a motion that we go on record as acknowledging that the board has considered the cost impact of the proposed rules, that we feel like that some of the aspects of the rulemaking hearing will add some cost to businesses, but other aspects of it will largely offset that. We feel like that where they may be a minor cost to businesses, that it would not be unduly burdensome. And so that would be my motion.
Second. Okay. We have a motion and a second based on the review of these, that we do not see any substantial economic impact on businesses affected by these. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Thank you for that. I have one last thing. It is in regards to a few complaints involving one company. The complaint numbers are 2012-008-481, 2012-014-821, 2012-014-881, and 2012-014-331. All four of these complaints involve the same company, and they all involve the unregistered, them employing unregistered individuals, numerous individuals, over the course of this last year. The board has been presented each of these cases and have authorized different civil penalties for each one, the total of which was $51,300. A consolidated consent order was sent by me to their council, and after the council has, council and I have discussed their willingness to accept that $51,000 as a settlement offer in lieu of formal hearings. They are willing to accept the consolidated consent order and pay the $51,000. However, they are requesting the board that whether or not that they can enter into a payment plan to pay off this civil penalty. Their proposal, if accepted by the board, is an upfront payment of $6,500 with subsequent payments of $1,250 for 36 months. Please be advised that if the failure to make a timely monthly payment, and council was made aware of this too, would result in the automatic revocation of their license. So there's some effects of not making a timely payment, and so I wanted to present that to the board, whether or not you would accept it, or would you accept another payment plan that they would be reasonable for this company.
Andrew, my personal opinion would be that a payment plan would be acceptable. I really hate to see that be drug out over 3 years.
Yeah, it's some paperwork. I won't.
That seems to be a long period of time relative to get this thing paid off. I would like to see it, the obligation settled in a shorter period of time.
You have a time frame in mind. If you reduce the time, I could and give me the approval, I could probably set up a payment plan for 2 years or 1.5 years.
I was thinking in terms of 18 months.
18 months would be something that would be reasonable.
I would think so. I see no reason to drag this thing out over 3 years.
Okay. Okay. 2,500 a month, maybe. I'll do the math and with the. If it's 2,500 a month, I'll do whatever the first payment would be. That would probably increase the initial payment too.
Is this a larger company?
Yeah. Yeah.
Something that they can.
Yeah, it can. They can, and that the consequence of not paying that monthly payment, which we would be the revocation of their license, the shutdown of their business. So they're made aware of the consequences of not paying. So I don't. Yeah, that is
If
included.
they
No,
miss their payment, they have no desire
that is included in there. I'm sorry.
to make the rest
The
of the
balance
payment.
is due. You're right.
They'll just reorganize, set up as another company.
Right.
Which we will flag anyway.
You wouldn't know it.
So,
This big a company.
if I understand, would a payment plan for 18 months at $2,500 a month be acceptable by the board?
I think spreading it out over 18 months, I didn't try and do the arithmetic.
I'll try. Yeah, I'm not sure. I don't have it on the top of my head.
That sounds good.
But okay.
Does need to be motion form?
Yeah, please.
I make a motion that we enter into a settlement plan with this particular company. I don't know the name of it, but the company that Andrew's presented. We enter into a settlement with a payment plan for 18 months with the what is it, penalties, $51,000?
$51,300.
$51,300 spread out over an 18-month period.
And
Yeah.
Second.
we have a motion and a second to accept this consent order with a balance due of $51,300 with an initial down payment and the balance spread out over 18 months. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Thank you. Appreciate it. I think that's all I have for you. I appreciate being counsel for the board since I got here. So you guys have taught me a lot about being an attorney.
We'd like
No, I
to take
appreciate
the
it.
opportunity
Been a pleasure.
to thank our Assistant General
Yeah,
Counsel
we-
for everything he's done for this program. Well, of course, we're going to still be working with Andrew Simpson because he's going to be your litigator. When we started, we had an enormous amount of complaints, and we've knocked them down considerable with his assistance. And he still will be available to help our new attorney, Josh, with anything he's going to need. So he's just down the hall, actually.
I think Andrew will acknowledge that he and I have not always seen eye to eye on issues. And there have been times I've been very critical of Andrew. There have been times I've been very complimentary of Andrew. I think Andrew has come a very, very long way and has done a fine job for this board.
I second that.
I've enjoyed the experience.
Well, my
Didn't
first
aggravate
question,
you?
my first question when Cody first told us, I said, leaving? And she said, no, just going down the hall, because my concern was you were leaving completely, but,
You haven't told me that yet.
well, we're not wanting that.
Josh, that's how it works. Once we get one train, they're gone.
Mr. Kilgore, out of the
Hey,
frying
we've
pan
kept you
into the
for,
fire.
What, 4 years, though?
2007.
Wow.
I'll never forget
December 2007.
Sure, we didn't come in. We came in together, didn't we?
No,
an informal that we.
I wasn't here.
Yeah.
Steve Allensworth was on the board still.
Oh wow. Yeah.
Yeah, and we had our first meeting up here in this building in that little room on like the 4th floor or something like that. 6th floor.
congratulations, and we wish you only the best.
Yeah, I will see you guys.
Okay.
Josh's going to take over. You're in good hands.
Thank you.
Okay. I think you're,
After
We got a monthly reports.
I think it's Ms. Vest's turn with
Right,
administrative reports.
Thank you. If you don't mind, we'll go ahead and we have Exhibit 8. Mr. Durham, I believe, is here with us. If you would, go to your Exhibit H. He's here for you to review his qualifying agent application.
oh, okay.
Excuse me.
Okay. Not going back to the agent. What? Okay, good. We got it up there. Qualifying agent application review.
H. Experience review.
It's
We have a-
education and experience both.
Okay, we'll just take a couple of minutes to review what's in the file.
I believe Mr. Durham.
Podium.
I have one. It does look like maybe perhaps some of the copies of his degrees or whatever did not copy. They
I
were
have
blank.
copies here if y'all need to review them. They're kind of dark and they didn't scan very well.
Nice and black.
Our 3, 4, and 5 looks like.
Well, again, they were
don't know.
that color when this is what the originals look like, so.
Up there, your certificates, is that what it is?
Yeah, do y'all wanna
I'll
look
do
at
those.
it?
Well, that's okay, as long as I, no, it's all right. You tell me what they were, I don't need to see them yet.
Well, again, he has a bachelor's degree in mass communications
Right.
with a minor in electronics.
And they're I saw that. I think I saw this. Okay. Did work on the paint.
Is he taking the test at CCT?
Wants to
We
take
just
it.
got his application February the 13th.
Right, and back to my old question, how's he gonna be able to test for it if Prometric didn't renew?
We have till March 29th. We'll get to
Okay.
that later. He knows he has to take it pretty quickly, and he was planning on taking the VIT CCTV course, but with the degree, he won't have to have that
Right.
if y'all approve his experience and his education. So,
You guys had a chance to look this over?
Mr. Durham, be glad to answer any questions if you have any. That's why he came in today.
One thing that stands out, I guess, is a good thing, is work in Tennessee, but you guys are nationwide with this device that you're selling. You're networking all over the United States, correct?
Oh, I'm not.
You're not?
Nashville, Middleton.
I guess what I see here is 280 different manufacturers across the United States.
I did it one time.
Actually says sales, service, and do maintenance work on their computers and everything that's connected with cameras.
This application is based on, let me make sure I understand what we're being asked to consider, based on the degree and 2 years' experience, or based on the associate's degree and 4 years' experience?
it depends on how you accept his 4-year degree, which is not in electrical engineering. However, in combination with that, he has a 2-year degree in electrical engineering and another 2-year degree in computer, yeah. And y'all can't read these, but we have on his, from Nashville State Tech, He has completed an Associate of Engineering in Electronic Engineering Technology.
Yeah.
And
Well,
he's
that-
also got the 4-year degree with a heavy interest in electronic and electrical engineering. And then the Associate of Science in Computer Technology is another 2-year degree.
Well, the 4-year degree, of course, is not an engineering degree. It would probably be close, coupled with the other degrees as well, which incidentally looked like they were you had some excellent grades there. I'm somewhat envious. I noticed you graduated. The one I saw there graduated with highest honors, and you certainly would be congratulated on that. It certainly we would be on solid ground if we looked at an associate's degree with 4 years experience, and based on what you're showing us here, with the first camera installed back in '07. So if we looked at the associate's degree and considered the at least a minimum of 4 years experience, then that would certainly be a rational basis to issue that I don't think would be subject to criticism. I was just trying to make sure I understood what we were looking at
Well,
here.
again, I wasn't really sure exactly how you would view it.
I
Because
understand.
it's a little
I think
unusual.
we would be on reasonably firm ground to consider these qualifications adequate, given the 2-year degree and 4 years experience, and especially in light of the extensive educational background here. I think we could look at it as easily with the associate's degree and 4 years experience. So I would make a motion that we accept the qualifications based on education and experience for Mr. Durham here, and that would be my motion.
I'll second.
Okay. We have a motion and a second to accept Mr. Durham's combination of education and experience for his requirements to obtain his designated agent, is that right? Qualifying agent.
Qualifying agent.
For CCTV. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Congratulations.
Good luck.
Technical.
But next you need to take the exam.
Yeah.
Right.
Program,
Yeah.
yes.
Yeah, that's,
And if you wanted to take the VIP course, you're still eligible to take it. You don't have to have it. Yeah, well,
I want to take it though. Different aspect.
it's a good course. Everybody that takes it says it's a really good course. And you also get a manual that you can use for the exam. So, I'll be glad to contact you Monday and make sure you have the right materials, but you passed the first one.
I got to.
Yes. Go on our website.
Into their site.
First you have to register and then you have to schedule.
Okay.
But if you get into it, and I know you can figure it out.
Okay.
I know you can.
Best.
And if you
Okay.
have any questions, just call.
I will. Thanks
Okay.
a lot.
Thank
Right.
you.
Thank you.
Durham, thank you, nice to meet you.
Gonna move into yours now.
Okay, we can go straight on into mine. We're going to back up a little bit. We're going to go back to Exhibit B. If I can get mine over here where I can see all my stuff.
Open complaint.
I think we closed out about 15 or 16 this morning.
16.
Was
Wait
it
on it.
16?
Yeah.
Wait, I
Okay,
got
with a total,
So down to the bottom.
B. Top don't work, I go to the bottom and it works for the top.
the total number that we're showing right now is 46, and we did 15 today. It gives you an
yeah, you have to
Budget
speak closer
effort
to
to
the
do.
microphone.
Oh, excuse me.
Yeah, I have put this particular report on the screen because Hannah did a really nice graph, if I can get it to stay on the screen.
Okay. It was what, 46? Yeah, there. It tells you what status that they're in. That is a different report from what we're used to seeing, but that's good.
There's the basic report you're used to seeing. I can't get it on the screen all at one time. It's all in one document.
46 minus. Okay. No questions on that. Would move right on to Exhibit C. This is your disciplinary report. We've got November and December and January because we didn't meet. I believe several of our board members were ill that month and we weren't able to meet. For November, I haven't even added that up, but you can see there's $135,800 and some hearing cost. Another one was $24,600 hearing cost. Another one was $1,250, and then there was an additional one for $1,250 for that month. And of course, I have showed you the other programs as well, so you can see what we're doing with those programs. December, you come over to your December 12 disciplinary report. You'll see the $650 penalty, a $100 penalty, a $250 penalty, and a $200 penalty.
Is the formal that we heard last, is it on here?
Last one that we did, it
okay.
was in, yeah. Isn't that the $135,500 one here in November?
I
just
see
don't
it
want
now.
Yeah, now you see it? I'm sorry, I had
Now,
been going.
you also have to realize that the two that are on the November report were formal hearings. We have a final order which assessed these fines, but neither one of them have been paid.
That's what I was asking. I thought when they hit the media, they were paid. No.
We have a final order from a hearing. They're on the report. Isn't that correct? But they're not. These two have not been paid.
Bill's been sent, but the check hadn't been received, is what you're telling us.
Time to put Josh to work on
He
getting
was
that
just,
money.
he notified us that he was going to fight it as he went out the door, and that's why I asked, was it on here? And then I thought, because it was on here, it was paid.
Well, if I'm not mistaken, if they don't pay, they go up the hill for collection. They don't come. They don't come back to us. They're going to go straight up for collection. Okay, that was November. I think we did December. I mean, you can go through here yourself and see this. In January, there's a little activity there. $350, $2,000 plus cost, a $250 civil penalty, and $150.
And the other one, on the January report, teleoptics, that also was a hearing before a law judge, and it hasn't been paid either, that I'm aware of. I know that.
If I'm not mistaken, that's the only one that we've done.
Yeah, that one we heard
Before an
before a law
ALJ.
judge.
That's the
So
only one.
it is also a final order.
All right, that was Exhibit C. We'll go on to Exhibit D with his monthly reports for November and December and January. We'll just take one at a time. Here's where we're talking. This one here is your December. Here's where, and it's on that December and January also. November, December, and January. The exams. No, we do not have a new exam in place. We do not have anyone who has bid on these exams yet. We're still working. They did extend it to March, wasn't it? I believe it was March.
They will
but
cease
they're-
giving our exams on March 29th.
Yes. So anybody's making an application, we'll tell them to get it taken real fast.
What we're in the process of trying to do is either be given or purchase the exam questions, but we don't even have that yet. So even after we get the exam questions, then we've got to find somebody to proctor it. So we don't have a good answer on that yet.
That's going to become a problem for the industry here in fairly short order.
It's going to be a problem for.
It's going to be a big problem. It has been a problem for some of the other boards. We had one board that didn't have an exam in place for a year and a half.
I'm going to drive the DQA bracket sky high.
We are really pushing to try to get an answer on
Yes,
whether
we're
we can
doing all we
purchase
can
the
do.
exam questions so that we can at least move forward and see if we can get a university or somebody to proctor it somehow, so.
I heard you use the term VTR. Did you could take this on your computer at home? I didn't think you could. It had to be proxied. I
We
just
can't yet.
heard that term.
It
Yeah, but
may
you
have
need
to
to,
go to
yeah, it
that.
may, we may very well be doing that as well, but of course we would come with you with that.
Is that the reason that Promeric was not interested in continuing this?
Apparently, it's very expensive to develop that test and keep those, well, however you want to word that, but
The
there's not
test
enough
bank?
people to, yeah, the test, but it's not financially sound for them to do. There's not enough to take the exam.
Plus the contract call for them to be
Yeah.
completely
Responsible.
legally responsible for any challenges. Not that they've really had any, but I think they've just changed their business model, and this is not. They're going to online type exams, and
Period.
it's just the whole examination industry's changing. So.
So taking it at home will be the thing of the future.
More than likely, that's what's going to happen. But then we've got to find somebody that can proctor an online exam that's willing to either accept our test questions, which we've already developed, but we're going to have to go over them before we release them to make sure that we have the correct answers, because then I believe the board will become actually legally responsible if there's a challenge. So that could entail some different types of contracts that we're not familiar with yet. But
Our legal department, the state's legal department is looking into that. If you want, we'll go over to the December. Of course, we still talk about the same thing, and who we're talking with the Assistant General Counsel Dan Birdwell there on these exams. But you will see that we do have one member who has expired. That's Mr. Tucker. Mr. Tucker has requested to be reappointed. I have not received any paperwork from the governor's office yet. We're looking for that anytime. Then we can go on over to the next month. You've got the same information about Mr. Tucker, same information about the exam, but it breaks down the complaints more closely if you want to look at those. If you do want those in writing, we can always email those to you if you were interested in any of these reports that we've got here.
all the months.
You sent those earlier?
Good.
I've been sending them so they don't have to
So you don't have to go through.
stress over the
Okay.
iPad.
I reviewed those in advance.
Okay, good.
I should look.
So now we'll go to Exhibit E. That's your budget review. Well, it's legislative season again. That's the way I've reported. We only had 2 bills, which we'll discuss at a later date right so far. And we'll be going back up the hill to talk about our budget again. So
When's the
I
sunshine?
think
Oh.
I haven't been.
16.
Yeah, we've been already. This
Oh,
board's
okay,
already been
right,
rolled
right.
over.
We got to what, 2016?
Yeah. We did that last year, if
Right.
I'm not mistaken. But we still may be called before the budget committee. Excuse me. But I'll just review it with you. It's last year you had 227,317. This year you have 232,367. We are anticipating this amount to be pretty close for this end of this physical year as well. The same things happened this year. This happened last year with several companies, entities changing. Employees having to reapply or transfer over. There's additional fees there. It leaves you a total of $654,677 as an adjusted balance or your ending balance. Of course, you know, as starting July 1 of every year, we must start over with a zero balance. That is not monies that we will be able to tap into. But we we'll probably be using some of that income for the new computer system. We're moving ahead. It's called Core. I talked to you about that before. That is one of the reasons the alarm board is not on the online renewals right now. All the other programs that we have are, a lot of, I believe, majority of regulatory boards are. But with this change that we were making with rules about the registered employee, it was going to be very difficult to send out this type of renewal that to get just companies pay versus this type of renewal now for the employee. So we decided to hold off on it after the rulemaking hearing. Said this change for the online renewals will not happen this year for your alarm board. It does for the other programs, but hopefully we'll have it in place. They told me they're going to put Core on first, which is a new computer system. Get all the kinks worked out of that, then they'll put any programs as they come on the online renewals.
That's the same system that works so
proactive.
well for DCS?
Oh, yeah. This is not the same database.
We would hope.
I have a question.
not.
I'm backing up a little bit, but we were talking about Prometric and the exams and bidding, and it says that PSI does the locksmith exam, and they've got a bid in on a new one contract.
They don't want your.
Does it not cost
program.
more? I mean, does it not cost about the same amount of money to do the exam for them? Because they have to go sit in person also, don't they?
Bid on your exam.
They didn't bid on the exams.
They were
They haven't
given
bid
the
on
same
anybody's
RFP.
exams but my locksmith program.
That's what I said. They bid on it. Isn't it? Doesn't
And-
cost as much.
I
They
would dare
already had
say
that
they
exam.
do.
They had that exam contract originally,
It expired
They've
in
already-
December.
and they
Right, right,
rebid
but they're
on
gonna
it because
re-
they already
rebid it.
developed that exam.
We were hoping they would bid on these exams.
And they may bid on proctoring the exams, we just don't know yet.
Negotiation with that, so.
I just asked because you have to go sit for it, and I figured it cost just as much.
Well, yes, for the item banks and everything, it's, and that was a new program that they took on, so they just did, they extended the contract. Prometrics have been with us a long time.
Prometric is actually the old block company that originally gave all the,
Rising to us. All right, if we don't have any questions about that, we'll just move on to F then, if I can get my. All right,
working better today.
we'll go to F, excuse me. This is your legislation. Like I said, I actually only had 4 pieces in the office. Two was over the PI program, and you have your 2. So we'll look at these. They're very simple. This one here, the first one is House Bill 0637. Now, this does not mean that they may not come back with an amendment and change the whole structure here. What this one is to add your 4-year degree in computer engineering, industrial technology, and industrial engineering as valid education requirements for alarm contractor's license. It amends Title 6232, Part 3.
Where it now says a degree in electrical engineering, they're gonna add these degrees. They didn't change any of the experience requirements to go with it, so.
It has a companion bill as well. All right. Now, the next one is Senate Bill 0436, and it has a companion bill. It changes from 90 days to 60 days the amount of time that must elapse following creation of a vacancy on the state board for licensing alarm system contractors before the board is authorized to appoint a person to fill such vacancy, assuming the governor did not appoint a new member to the board. It just changes your dates, all it does. Back from down the hill with some other amendment to it.
That
We didn't see
particular
any
bill
impact.
is the caption bill, isn't it? That one that changes the term. I think that's the association's bill.
don't know.
I have no knowledge of that, but
Yeah.
yeah, that sounds like a caption bill.
It is, and we were told it was, but I believe that's the Tennessee Electronic Security Association's bill.
Okay, without any other questions, we'll go ahead to Exhibit G, which is a company asking for another extension I-Systems Corporation, I had already extended one extension. Of course, you know, they have to bring it for the board for you to make the second extension to replace the DQA. You want to take that's their letter asking for the second.
We're going to take the test by the end of the month.
Now they're just looking for another.
I checked yesterday. They do have an open applicant on file. We've sent his print cards off. I think I'm waiting for some additional documentation to verify his experience, that he needs to go ahead and, he may have taken the exam, but they do have an applicant on file.
Guess we need to take action on that.
Yes, we need to.
I'll make a motion then that we extend for another 90 days request for, or that we grant the request for second extension to replace their DQA for another 90 days.
Second.
Okay, we have a motion to this company in pursuit of a QA. All in favor, voice by saying aye.
Aye.
Any opposed? Okay. Also, I don't see any numbers on their certification or license numbers on any of their paperwork. It's not there.
I'm looking there, but
That's
I
the
can't see.
address.
I got mine.
Right.
I noticed that.
You did, yeah.
You need
Like to have a complaint established, well, that's what we'll do, for not having their license number on their correspondence.
That's
As
correct.
required by rule. All right,
All right.
so noted. We'll do it. Okay, now we're going to move right along. If you want to, we're going to go right into the alarm application review. We've already talked to Mr. Durham. The next one is going to be I. Yeah. History review. Turn to that. I was kind of looking this over. If I'm not mistaken, this gentleman has already been presented to the board before and approved with the
For an
same,
employee.
yeah, with the same record. And I believe somebody had to recuse themselves.
I guess I need to go on record as saying that I can't be involved in that since Ricky's my employee, has been my long-term employee.
He needs to be under scrutiny right now. I'll stop you.
If there were any questions, I guess I could answer them, but
Yes, you could answer any questions, but please, if you're going to recuse yourself, do not vote. I believe we have the material in here from the last meeting as well. Was that 90? Some.
I just
think it
copied
was
the
back in-
minutes. It was in, I wrote it at the top.
93, that's what I thought.
93.
Nothing new there.
20 years ago.
Yeah, we,
Approved him as a registered employee.
Years ago?
Yeah, his registered employee number is 2.
He wants to be a QA in 3 different. No, I just wasn't sure I was hearing.
he's a,
Going to be 3 classifications.
Of course, you do.
nothing's
You do
happened.
have a letter from his qualifying agent of the company as well,
Nothing,
as required.
and we don't have any changes since.
There has been no, but I could tell there has not been any changes. You're looking at the same thing you looked at,
Right.
whomever looked at in 93.
Make a motion, we wait for a qualifying agent applicant.
Okay. We have a motion by Mr. Harvey.
I'll second.
We have a motion and a second to approve this person's application for qualifying agent in the 3 listed categories. All in favor, voice by saying aye. Aye. Any opposed? Motion
Made
carries.
that motion.
Mr. Harvey and Mr. Tucker seconded.
Second, thank you.
Certification number 1.
And his employees know.
Wow.
Okay, are we ready to move on to the next? Is our alarm employee application review. And this was going to be J. These are all based on the criminal records that have been provided to us. The first one here was denied for material misstatement, so this is a reapply.
Are we in the file, J? Okay.
If they had been previously denied him in, I put that on top and put the new application behind it, just so y'all could follow it better.
Well, we're looking at a 1986 embezzlement.
Ow. Pull the check.
Assured.
Left that out in the initial application.
Material misstatement, just in so long ago.
So what was the outcome of it? Does it?
Gentleman was guilty. Had to pay restitution. I say Jeff. Served, I believe it says in here he served 20 days and got 11.29.
Is it a felony conviction, or did they reduce it to a misdemeanor?
I couldn't tell. It wasn't but $200, so it had to be misdemeanor.
They charged him with a felony. He took a check that was made out to his company and somehow cashed it. Or it was supposed to have been made out to his company and somehow cashed it.
Thought he was due and he didn't.
Got a letter here from his qualifying agent.
Oh, with him being.
You might take your check.
And you saying you wouldn't take his check?
No, I said as long he might take his check. Cash it.
Are you gonna make?
I make a motion to accept Mr. Alliston's application for registered employee.
We have a motion by Mr. Harvey to grant Mr. Alliston's employee registration applications. Do we have a second?
I second. If Mr. Miller here, it looks like he's QA president. Not worried about it, I'm not.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Now I gotta get out of this.
That was J. Next one, which is going to be K. We're bringing back today several files that have got old convictions. Right on the documents.
I got to remember not to write on the iPad. What are you talking about?
Sometimes it kind of helps.
It does me, and I have to go back and look
Well,
at
I
it,
want
but,
them on there mainly so, because
Don't put no
there's
white
so
out on
many
the
of
screen,
this one,
Ken, you're
especially.
right.
well, I had written down it was a 1980 burglary that, theft,
Right.
that he was guilty of. To look through.
And you said this was a reply?
No, I didn't say that.
Oh, okay.
That was the other one.
I can look it up.
Got a letter from the qualifying agent, said he's aware of his arrest that took place 30 years ago. It's taken
Read
him a
about
long
it.
time to get the information together to send in to us. That's the last document. I believe that's the last one.
This is the first application he submitted. It was submitted in April of 2012.
It's taken him a long documents. Is a little old.
His hire date, well, again, he's an applicant and he can work, but his hire date is listed
March
as
22nd.
March 22nd. We got his application on April the 10th.
I'd make a motion to accept Mr. Brookman's application for employee registration.
Second.
We have a motion and a second to approve Mr. Brookman's application for employee registration. All in favor, voice by saying aye.
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 Opposed? Okay. Motion carries.
We can go to L now. I believe we're on L. This one here, the original one was denied for material misstatement, had to reapply. His old charges as well back in 96 and 97. He has a current 2007 charge, but
Just a FYI, on his previous denial, he did disclose 2 charges and then explained that he thought one of them had been expunged and it hadn't been, so. He didn't say, no, I've never been arrested on his first act.
Best I can tell by looking at that, the battery and the assault, it looks like the court documents in front of where the judge signed it, to where the case was dismissed with that Colorado statement there, and then the charges behind that.
Did he have an arrest in 2007?
Looked like it, yes.
That's what he did not
Assault,
disclose on
reckless-
his
It's reckless
first ask.
endangerment, yes.
Reckless,
driving
yeah,
in
he
an
said he pled to a lesser charge,
Guilty plea.
but
Probably may be.
What, pled
But
guilty?
they would hear that every single day, every day.
I've heard expunged. I've not heard that 1 year thing.
They clean for a year, it should be expunged from your record. What they neglect to tell you is you got to pay to have that done.
And you
Yeah,
have to
right.
go back to court and request it yourself. It's not automatic.
And you get a copy of it.
Yeah, because once it's expunged, there's no record. You can't get a copy of it.
Oh, your expungement. They give you,
Yeah.
I've seen people have copies of expungements.
We tell them in office, you have a copy, you need to keep it for life.
Make a motion, we accept Mr. Kevin Brown's application for registration, employee registration.
I second it.
Okay, we have a motion and a second to accept Mr. Brown's employee registration application. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Front of it, we'll go to M. Now, these are all registered employees. Said yes on the application, had a couple of DUIs, and then we had a violation of probation. The probation does not end, or did not end, until May of 2012. It's supposed to have ended in May of 12, according to his writing here.
Next 4 months.
So do we know what the violation of probation and the bond revocation?
All due to the DUIs.
He Can go to the alcohol
Probation
drug
requirements.
court.
Like he was charged with it every 2 weeks for a year. And it might have been every time he went to his probation officer and hadn't
Or-
done whatever he was supposed to do.
Or didn't go.
Yeah.
You do have a letter from this qualifying agent as well. That's the
Got a
last
letter.
document there.
Madam Chairman, I make a motion that we grant this application for registration.
Okay, we have a motion to grant this employee application. Do we have a
Second.
second? We have a motion and a second. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Put our agenda back up there so we don't have to keep.
Yeah, I'm sorry. I had RBS up and
Board, how many more of these do we have to go?
We're in through T. Yeah.
6.
The board is entertaining the thought of taking a lunch break.
6 more.
Well, that's all you have on the agenda, other than education. Of education? Yeah.
Can we do the
yeah,
6?
but it's not real extensive either.
That's 6.
I think we're going to take a 10-minute.
For me?
In?
Bed up there.
I think we're ready for
Yes,
N.
we're ready for N, all right? If you're ready, we'll go to N. It's a few pages as well. It's a new application. Let's see what I got down here. Yes to that question, have you ever been arrested? This is a larceny from 1995. You will see if you pay attention to G, right under G, we have different lines for you to put the different charges down in your sentencing. Apparently, he says not available due to age. We do require the individual to get the court documents. We don't, no matter what the age is. Then if it's not available, of course, they would get something from the court that says these records are no longer available, just like we are having to do now since the 2010 flood when we had so many records in the basement. They're just not available. attorney is here if you have any questions. Looks like this has already been represented before, Beth. You've got reviewed it.
That was in 2003. I went back with, if they had an old file number, I went back and looked up to see if
The
they had been
application
issued.
was approved at that time.
Yeah. Did he
Yes,
have
it
any
was.
charges after that?
And after that,
I guess that does bring up a question.
Yeah.
After,
It was
if I
sent to
see
Beth
the-
Van Dyke.
Press a girl.
No,
I-
his email was sent to Beth Van Dyke.
Oh,
That is the, she's at Fleener.
Oh, I
She's
thought he
the-
was trying to send
No,
it to
she's the
you.
administrative assistant at Fleener in Knoxville.
I was going to ask the board, if I do see that an individual's making an application again, and the criminal history has been approved by our, and I can go back to the minutes, and there's no other charges, do I need to bring that file back to you on there?
Say no.
Oh.
Nothing's changed, no.
As you can see, that's a couple of what we're doing here today, we're bringing some of
I'd
them
make
back.
a motion to grant this gentleman the employee's registration.
Motion, we have a second. Motion and a second to approve this person's employee registration. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Right, we'll go to Exhibit O. This is a new application. This does bring up, if you look at his application, just happens to be this gentleman's here, you'll see two photos are attached. If I'm not mistaken, whenever we ask for the photos, because of course we're going to put them on your license, whenever we are barcoding, this is actually, it looks like the same, those photos are not in color, so whenever any registered employer, qualifying agent wants a duplicate license or make an application again, they are going to be required to submit new colored photos. So you're not going to be able to keep the color photos they have sent. That's why whenever we take another look at these rules for another rulemaking hearing, maybe we can knock down 3 colored photos to just 1. Get online and get the new renewal set up, we might want to take another look at some of these rules. These are pretty new charges. These are 2011.
Expunge.
Yeah, he knows what.
That last one, that burglar, was amended down to theft of property. Tried to match up those, note on there, I tried to match up the expungements to go with the charges.
I tried to put everything in date order yesterday, just so it'd be easier to follow, but some of this is hard to find the dates on it.
Oh, he's saying
Looked like no,
charged with theft of property.
it was just,
Because the owner
prop-
came down and tried to drop charges.
This one's a little odd, because if you'll notice, his fingerprint report for Tennessee says no record. I'll put that in there.
Motion. Application.
Employee.
To accept the employer application. Do we have a second?
I just have a hard time. Somebody had been convicted of burglary 2 years ago, well, 2.5 years ago now. Farm industry. I guess I just have a problem with that. I don't see evidence that this is a gentleman that should be in the business of installing burglar alarm systems in people's homes and businesses.
I concur with Mr.
before you have a motion without a second.
Correct.
I make a motion we deny this application.
We have a motion, we have a second.
I second that.
We have a motion and a second to deny this gentleman's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed?
So the-
Motion to deny passes.
So the first motion died for a lack of a second? Okay, thank you. I believe we're going to P. It's a long one, sort of 3 pages. It's a new application. Said, yes, it was arrested. There's not very much there. Disorderly conduct in 2006 in Arizona is what he says on his application. He was on probation and found guilty for 3 years got 3 years for domestic assault. Look, that was an old arrest record, is right.
From the Diamondback.
Two was the domestic. Excuse me. 6 was disorderly conduct.
What was the Diamondbacks?
That, what is it, this,
On his app, it should say
so I'm trying to.
he's a technician.
See this, he's
So he's not gonna be working for a company in Tennessee, he's just gonna be a registered?
This is these people that come in here every year and spend the summer knocking on doors and installing alarm systems. This is one of the Utah companies that
Right.
is really
Yeah.
strong in door-to-door sales, and they install the system as soon as you say maybe.
or
They're
slightly
in your
before.
house installing the system.
So just for the record, for the guys who's in, of the group who
Madam Chairman, I don't see anything in the two charges that this young man has been convicted of, the two disorderly conduct charges that, in my mind, would bar him from being in the alarm industry or present a threat to the citizens of Tennessee. So I make a motion that we grant this registration.
Okay.
second.
We have a motion and a second to grant this gentleman's employee registration application. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
I believe we're down to Q.
He applied. Has he been approved already? Just asking.
He actually held registration, but I could not find where it was ever presented to the board. He was with State Systems, which is the same company I think he applied with this time. Yeah.
He was a registered employee before.
He was, and it was issued in December. I back and looked at it yesterday, but I could not find where it had ever, how it got approved, but it did.
Got a 95 assault conviction.
He left that company December the 14th of 2010, and then reapplied.
Gonna be nothing but employees. So last charge we got on him is 295, and evidently he's worked since then.
I'm making a motion.
I second it.
Okay, we have a motion and a second to accept Mr. Palmer's employee registration. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Then the next one is R.
Give you a moment to look at R. This is a little different because he just got off of probation in 2010 for possession of controlled substance, which he got 5 years probation, and child support 5 years probation, was both ended according to him. And notice the letter is from the DQA, this company that we're all aware of. This is a very extensive for as the letters I've received on a registered employee. So, I'd like to take.
Right, it would up for one of his.
Was more than 2 lines.
Yeah.
That I normally get. Should the gentleman still owe child support and become a licensee, we will be hearing from the Department of Child Service. Attaches what? Do it every day.
He's an installer.
Off early.
What is
He
this where he
violated
had
it
a,
and had to finish it.
he had a probation violation? What charge was that?
I don't know, and he didn't.
There was an order to continue probation in 2007. He completed it January 31st, 2010. He was released early for the, for one of them. The one that he completed in 2010 was the non-support.
Madam Chairman, I don't see that, or in my opinion, this record would not be something that I would consider a danger to our citizens, and therefore should bar him from being employed as a member of the alarm industry. So I make a motion that we grant this registration.
A second.
Okay, we have a motion and a second to grant this individual his employee registration. All in favor, voice by saying aye.
Aye.
Any opposed?
Aye.
You're opposing?
Mm-hmm.
Records show that the application.
Go to Exhibit S. Statement applied as these are very old charges, possession 87, 88, and 90.
Last chart.
Make a motion.
I'll second.
We have a motion and a second to accept this individual's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. The last is the T. What is T?
Well, I looked at it, even though what he said on his application, he has DUI in 2008, 2009, 2010. Closed some dates, but not the DUI. He called them different, implied consent and what, different things. As you go through, he'd try to give me some punishments, but
it before?
Battery says driving. Oh, he was sitting. He just pulled over to the side of the road drunk. Is that?
Go over the side of the road, you got your keys in the ignition, that's a DUI.
The keys in your pocket, right?
I think they have to be somewhere outside the vehicle, like in somebody else's pocket, 2 miles away.
Sterling letter recommendation.
Nothing. Lawsuit. Wait.
It's our job.
People. Well, let's see.
If any of these they're required to turn that.
Hard to tell us the conviction.
And if DUI is not listed in your TCA, they don't have to notify you. They only have to list you of those limited crimes that are listed under the definition of poor moral character.
Most companies
Most of them go ahead and
will
notify
tell
us.
us of
And
any arrest.
in a lot of cases, especially if they get a DUI, they get terminated because they can't drive the company vehicles anymore.
Our standpoint, us there.
When he issued it,
Yeah, you would have to take steps to revoke it or suspend it or something.
Madam Chairman, I feel like that even though I'm not sure I'd want to have this particular individual driving one of our company trucks, I don't see that, or I don't feel that his record should bar him from being in the alarm industry. So I make a motion that we grant this registration.
have a second? Second. Okay, we have a motion and a second to grant this individual's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? I oppose. Motion carries.
What are you looking at? I
Vote,
oppose.
Mr. Tucker.
I didn't.
Okay,
Aye.
Ms. Jones, did you vote?
I vote, I did, in four.
You voted against, Mr.
Yes.
So 3-2.
Still passed.
Yes. Okay, I think we're ready for education report. And this is not on the iPad, correct?
Well, the list of them is, but
Oh, I see, sorry.
who had
I did
Mr.
reply.
Muse, William T. Muse? Did I give that to you, Karen? His notifier factory training?
Yeah, I had a
Oh, you
question.
gave that to me.
Okay.
I have
Sorry.
that.
Well, your mic is hot.
But when you're hot, you're hot. When you're not, you're not.
I need to roll it down.
Do you want to take up this Muse continuing education certificate?
He was the one that completed the 40-hour Honeywell notifier training.
That the, and he's just submitting this, as I understand it, for continuing
For
education.
himself.
Yeah, I would be willing to grant that as continuing education. I'm somewhat familiar with this particular course. It's a very rigorous course. It's 40 hours. If he's just looking to use that for continuing education, I would feel like it's certainly justifiable. So I would make a motion that we grant Mr. Muse's continuing education based on this certificate of factory training from Notifier.
Okay. Motion, do we have a second?
I'll second.
Okay, we have a motion and a second to grant Mr. Muse's continuing education hours. All in favor, voice by saying aye.
Aye.
Uh-huh.
All opposed? Motion carries. You have another one?
I do. I was given a course for review. Brad Shipp, the executive director of the Texas Burglar and Fire Alarm Association, has asked that their level 1 course be approved. It is a 16-hour course. Certified alarm technician, alarm level 1. Basically, it would be similar to the NTS level 1 course, but since it's from Texas, it has not automatically been recognized by us. So I'd make a motion that we recognize the Texas Burglar and Fire Alarm Association level 1 alarm technician is meeting our alarm level 1 certification requirements.
We have a motion by Mr. Roberts to accept this document.
I'll second.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
Aye. Any opposed? Motion carries. You didn't have anything else?
No, that would.
Who had Mr. Oberly? Okay. The Monaco training?
Yeah, my question is, did his license expire
No.
November 30th?
No.
I was looking at this page that you printed off.
Actually, yes, because he's in Africa and he only has till the end of this month to renew, and he turned that in, but we canceled the meeting and it hadn't had an opportunity to be presented. He's
Okay.
actually working in Africa right now, but he should be back in the next couple of weeks.
Well, and after that, the next question is, his letter, what I'm gathering is he wants to know that he's co-author and all the hours that he's been working on it.
That's a
And
whole
then this
different person.
certificate, is that for his credits to go toward renewing his QA license?
You talking about Mr. Staples?
I guess I am,
Two
but I'm
different ones.
confused.
Oberly took the Monaco Enterprises 40-hour fire training course.
Oberly.
Overly, John T.
Okay.
Did he not have the print screen on front of it?
Yeah, that's the one I asked, did it expire in November?
Yes. He's paid all his fees, but since we hadn't had a meeting, I couldn't get this approved or reviewed.
But he has all of his credits. Doesn't he, to renew?
No, that's why you have that in front of you. It's for renewal. He wanted you to accept that to meet his 16 hours of continuing education. The Monaco training.
But that was all taken
It's a
at one time.
40-hour course.
Right.
It's pretty extensive.
A whole week.
Monaco does a good job on their training.
I'm not familiar with them, but if he spent a week on this, it's had to be intense. Because I had a 2-day course that was, you about pulled my hair out. Yes, I would make a motion we accept this.
His
As
continuing
his
education.
continuing ed.
Second?
All right, we have a motion and a second to accept Mr. Overly's documentation from Monaco for his continuing education, Monaco Training Systems, or whatever it's called. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. And you have
And
one more.
now we have Mr. Staples.
Now this one, yeah, I was asking you, he's the one that wants to know, is his co-author and of this course enough credits gonna, boy, my vocabulary.
Okay. ISET awarded him 10 hours of continuing education credit for working with Prometric to develop our exam questions.
And he wants it to be his 16 hours of continuing
No,
ed.
he's asking that be considered to meet his continuing ed requirement. There were some other courses that NICET accepted that I'm sure he had to show them certificates of. I think the real, and I'm sure he can send us copies of those also, but the real question is, will we do the same thing NICET did and award him 10 hours of credit for developing exam questions for our exam?
Yes, I see no problem with that. I make a motion we accept that.
Okay.
Mine were confusing.
We have a motion to accept
Did
presented
that on purpose.
documentation for this individual's continuing education
Second.
hours. We have a second. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
The only items left are the new Elite CEU courses, which,
I have.
no, you have the resubmissions.
Okay, you've
Keith has the new ones. There were only,
5 new ones that they're
Five.
asking for 1 hour each on for continuing ed.
most of them still seem to deal with LAN and network access.
They all look good for an hour of continuing ed.
Second?
motion and a second to accept the new continuing education courses presented by Mr. Harvey from CEU. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Now, the ones Vivian has are all the resubmissions. They were resubmitted under the exact same titles that they were previously approved on in 06 and 05 and 0. But they have expired because your rules say that courses expire 5 years. They have resubmitted everything that was within the realm of expiring, just to make sure. I didn't see any changes at all.
I didn't see any problem with it at all, because a lot of them are 1 and 2 hours, and then the one on residential fire is 4, but they're very well laid out with the syllabus and what's description, what's required.
So what will happen on this, if you do approve them, then we'll go in and assign them new course numbers and a new expiration date.
I make a motion that we accept these newly submitted classes from Elite CEU for renewal. And just a housekeeping.
Second?
A motion and a second. All in favor, voice by saying aye. Any opposed? Motion carries.
have anything else on the education report.
Have any unfinished business? Kilgore? Nothing? Hannah, folks in the back? Okay. Any new business? Yes, ma'am.
I have two items that I want to kind of inquire about. We have several excluded contractors who have electrical contractors licenses and have filed for an exclusion. So they're on our list of excluded contractors who have since retired their electrical contractor's licenses. We actually had one file for the exclusion on a retired license. Your rules don't really identify that they have to have an active or valid contractor's license. Cody and I kind of think that if they've retired their electrical contractor's license, they don't have anything to be excluded under.
I agree.
True. And we really kind of need
Guidelines.
some
where we need
guidelines.
to rescind that exclusion, tell them they're no longer excluded because their contractor's license is retired.
If it's not active, they don't need to be excluded from anything. It's already retired.
Is that something that needs to be in our rules?
I believe we're going to put those in the rule, but
Yeah.
in this rulemaking hearing, something's going to need to be added.
Since we've just got a proposed rule-making hearing, can we put it in that as well?
I seriously doubt that. Those have already been approved all the way up the channel. To stop them now, you're going to throw out the rules for at least another 2 months after August before.
What about retired QAs that are going to want to try to come out of retirement?
You don't have
You
the
don't have
authority
the
to
authority.
retire a
There's-
license.
We don't have that.
You don't even have it in your law.
It's true.
So
if they
you don't-
expire, they've got to reapply.
But if you don't have a company to attach your QA to, if you're just a standalone QA,
Well, we have to get,
Call
we
it
get it.
independent.
okay.
We call them independents,
All
but
right.
we get a statement from them that says they understand they can't be employed or do any alarm work unless they're employed using their license by an alarm contracting company. We've had a couple of active QAs that have transferred to excluded contractors. So having that statement in the file is kind of a moot point, but we make the statement say, you know, again, we can't keep them from working for an excluded contractor, but they're not licensed with that excluded contractor. Their license is held with their home address, and that's the only information that we have. We had asked for some law changes to add the possibility to retire your license to the law, but that's never been addressed, so we can't draft any rules because we don't have statutory authority to do that.
I think the board should go on record as clarifying the electrical contractor exemption to the effect that it needs to be an active electrical contractor and not a retired or disbarred, or that it needs to be an active electrical contractor in order to be applicable for the exclusion. And I think the board needs to go on record as saying that. So I'll make a motion that we, so that it becomes official action, I'll make a motion that we clarify the electrical contractor's exemption to the effect that it has to be an active electrical contractor.
I second.
Mechanical or HVAC.
Yeah, the exclusions, they have to be an active license or a valid license.
I'll talk with Josh and Andrew, see if we can get that in the.
Seemed like it'd be a real good thing to do, since we actually haven't had the rulemaking hearing yet, and it hasn't gone to the Secretary of State and all that. I think that's not a major rule change. It really is more of a clarification, but if we could get that into our rules change that we're proposing, it would make a world of sense to go ahead and do it.
I think we'd only have to add
Oh.
one word to the existing rule.
It should, I haven't looked at the wording, but it would seem fairly simple to me, and I think we ought to go ahead and do it rather than, because if we go to wait for another rulemaking hearing, that's going to be a year or more away. So I'd like to see it included in the, so I've got a motion to clarify that. Maybe we ought to go ahead and vote on that.
Seconded. Okay, so we have a motion and a second to attach the word active to these licenses before they can be, what was it, excluded, yes. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
Madam Chairman, as a second item that really is a portion of that, I would like I'd make a motion that that be added to the proposed rules hearing that we've got, if that can be conveniently done.
Second.
Okay. We have a motion and a second to add this correction or addition onto the current rules making that we've had presented to us today, as long as it doesn't stop the process of these that we've already approved.
Or create a major delay.
Correct. All right. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries.
I have one other minor item.
Go ahead.
We have a qualifying agent who transferred to a company to get it started and licensed. And he left that company about 12 days later. And he provided a statement with it that said that based on Tennessee law, he's required to be a full-time employee, and that his employer had required him to get his own workers' comp insurance, to get his own file for an exclusion with the state of Tennessee, saying that he wouldn't file a workers' comp claim, that new law that took effect for contractors.
Right.
And expected him to be paid, as contract labor. And he wrote a statement when he turned in his transfer form. And I've heard this from several people in the past. Your law requires that they be full-time employees. We
Right.
no longer require that affidavit that says you're a full-time employee. And I don't think you need to really take any action right now, but I think it's something we need to kind of watch, because I know a lot of these QAs just get paid and never set foot in the office. But this particular instance, I mean,
Contract labor QA.
yeah.
That company needs a letter of warning about our rules.
Now you're really going to open up a keg here. You say he has to be a full-time employee. Well, he's there, he's getting his job assignment, he's getting a paycheck every month, and he's getting a 1099 at the end of the year. Does that make him his own company? That's right.
From my
It does
understanding,
under the workers' comp laws for Tennessee and the Department of Labor laws, it does.
They want him
He
to
was
pay
gonna
his
have to
own.
go out and get his own business tax licenses, buy an insurance policy, file a $200 exemption with the Secretary of State's office that he was exempted from his own workers' comp policy that he was gonna have to pay for. And he didn't feel like that was his role as a designated qualifying agent for this company because of the Tennessee law that says he's a full-time
Did
employee.
he agree to all that before he signed it? I'll work for
they
you.
probably
No.
didn't tell him.
Right, and find out.
He'd already transferred and gotten the company license,
Then-
and then they told him he had to do all this, and so
Right.
he left and went somewhere else.
He did what these owners do.
I don't think we need rules or anything on it. Well, we might, but I've heard this before, because I get an awful lot of phone calls and nobody ever provides anything in writing. So we might need to go ahead and try to define full-time.
Let me tell you
employee.
what scares them is the one thing when the state says, okay, we'll pull the payroll records, that makes people legitimize whatever they're doing.
You know, a lot of these small startup companies, you know,
It doesn't, but this guy would have to be a full-time employee there will be some payroll records saying that they're taking taxes on him. He's an employee, not a contractor.
They're giving him money, just regular contract, at a lower rate, not like administration pay. But he's upset because they want him to provide his own workman's comp and his own this and his own tax licenses and et cetera.
But if he, if they're paying him on a 1099, he's considered self-employed.
Right, he's
Exactly.
self-employed.
How could, he would
I don't
have to
see
be his
how
own
he could
QA
be.
then.
Yes.
Well, that's exactly-
He owns he owns a company.
And then he gets in the bind because he is going into a partnership with an unlicensed alarm
Right.
company.
Yeah, 'cause
Right.
he's his own entity and he's
That's right.
an activity with unlicensed.
I think it's something we need to think about, maybe coming up with some rules that would kind of give people some guidelines as to what, all we have right now is that your designated qualifying agent shall be a full-time employee.
Well,
Just
that's in
have to say
the
it doesn't
statute.
I know.
The statute specifies that. I mean, that's,
I think we're trying to
That's
say
statutory.
what designates a full-time employee is what's coming into play here, right?
Well, that, and we've crossed that bridge before and tried to define it, and really, that's almost impossible. And we don't normally regulate how these companies pay their employees, but since your law says they have to be a full, maybe it's just something we need to kind of come up with a creative way to address so that the companies have some guidelines.
W-2.
Well, I don't think we can require that.
Yeah, we
I
got
think
all
the
this-
Department of Labor can require that. But no, that's not something we regulate.
Adjust some work.
Right. Under some case.
That's all I have.
Hey, Josh, once you're here about 6 months, Cody will move to the other side of the room. You'll be over there by yourself.
It might happen next month.
that's really out on a limb.
Hey, if she, those two guys at the end of the desk.
See, she got to sit over there with you and make sure you know how to act right, and then
Yeah.
she'll kind of distance herself from you then.
Oh, gee whiz.
All right, anything else? This meeting is adjourned, and we'll see you back 1 month from today.
I
Yes,
got
ma'am.
one other thing I don't think it has to be on the
Okay.
record.
Let's-
I don't believe we have any hearings in March.